Welcome to today's program, Student Loan Collection and Servicing Issues in the COVID and Post-COVID World. Copies of the slides, a link to the recording, and the CLE verification form will be emailed to you in the days following the webinar. During the program, a CLE code will be read aloud, and you will be required to include this code on the CLE form. Throughout the webinar, please feel free to type your questions into the Q&A box on your screen. Now, I'd like to turn it over to Bill Hanlon.
Good afternoon, everybody. It's a good day to be inside and attending a webinar, because if you're here in the Northeast or in other parts of the country where the temp's above 90 degrees, you realize what a great day it is to be inside. I'd like to welcome you to our seminar. And Colleen, if we could have pictures of our speakers up there, beautiful. I'm joined today by my partner, David Bazar, who is chair of our Consumer Financial Practices Group. I am chair of Seyfarth Shaw's Bankruptcy Group, and Annie Dunn is with us. She is an associate in our Boston office with several years' experience litigating consumer financial issues. Next slide, please, Colleen. Today, we would like to cover 4 topics. We would like to cover the federal student loan payment moratorium, what's in the American Rescue Plan tax relief, loan forgiveness initiatives, and developments in bankruptcy discharge. And I'd like to start with the federal student loan payment moratorium. Next slide, please. Unless you've been living under a rock, you know that payments on federal student loans are paused through September 2021. That was part of the original CARES Act, and those protections were extended by executive order, they apply to federal student loans. Payments under private loans were not eligible for the moratorium, but many private servicers put hardship programs in place. That's been good news for most student loan borrowers. They've been able, those with the ability to pay have been able to pay down their principal. They have not been able to take student loan interest tax deductions because there has been no student loan interest tax, and so no student loan interest paid. So that's kind of the one downside of this, but a small price to pay for the ability to have relief from student loans and student loan payments. But all that is about to change. And let's go to the next slide, please. 1 out of every 5 Americans starting October 1, 2021 will start paying their student loans. And they're going to start paying an average of $400 per month towards their aggregate $1.7 trillion loan balance. That is a high number, and to put that number into perspective, Annie, you looked up what was outstanding on residential loans in America, right?
Correct.
How much do Americans owe on their homes?
Right now, the aggregate loan balance for residential mortgages is approximately $10 trillion.
So $10 trillion on all the homes in America and $1.7 trillion on all of the student loans in America. This is a big deal, and it's going to be a big deal for the servicers when the collections restart. David, what are your thoughts on some of what the servicers' challenges might be when they start collecting again in October?
So when first thing the servicers are going to encounter is a bit of an attitude from everyone, from their customers to their regulators. This sort of this thanks for leaving us alone for the last year and a half, but now where have you been? And what are you going to do for us now as folks start to wake up to the fact that they're suddenly owing money that some of them are not going to have and others are not going to want to pay. And the servicers, you know, and this has been a long time now where there haven't been these payments, are going to have to confront a rapidly changing environment because it's instant, it's on a particular day, where they'll go from 0 to full speed, and now they're going to have infrastructure issues of having to do that quite so quickly, with lots of problems that have gone unnoticed for a long period of time that will suddenly be noticed, potential personnel shortages, training and experiential issues, turnover in personnel, and just a simple lack of institutional knowledge having been hollowed out. All these things will start coming to the fore all at once.
Right. I don't suppose any of those student loan borrowers will have moved in the last year and a half. The challenges, I think, are going to be formidable for servicers, and those that we've spoken to are gearing up for it. But it is going to be a challenge to put this back into place and return to normal come October 1, 2021. Let's talk about the American Rescue Plan and what it contains and what it doesn't contain. The American Rescue Plan was passed into law on March 10th, 2021. It's part of the $1.9 billion stimulus, and student loan debt forgiven through income-driven repayment plans was declared non-taxable from 2021 through 2025. That is a relief to those few students who have been able to qualify and carry out an income-driven repayment plan, and it relieves them of so-called phantom income, which would adversely affect their tax situation. You know, it's one thing to be forgiven a student loan debt. It's another thing to have it count as taxable income on your tax returns and then have to pay taxes on the amount that you've been forgiven. So that was a welcome extension of relief for those borrowers who qualify for an income-driven repayment plan. Along with that relief, there is a mandate for the Department of Education to streamline the income-driven repayment plan program and advertise it. What is an IDR plan? Well, it's been around for a long time, and it allows student loan borrowers who are experiencing difficulty paying their loans due to lack of income to apply for and limit their payments to 10 to 20% of income. However, this program has a very low participation and a low success rate. Part of the current administration's plans for relief is to restructure and advertise IDR programs and get people to pay what they can afford to pay. What's missing from the American Rescue Plan and Biden's $6 trillion infrastructure plan and the $1.2 trillion plan that has supposedly gained some bipartisan support in Congress. Well, in a word, loan forgiveness initiatives are missing from the plan. I've got some statistics here that might help put this into perspective for you. There's a kind of vigorous debate over whether there should be loan forgiveness at all, and if so, how much. The debate kind of finds its roots in the expansion of the student loan borrowing programs to begin with, and now we've blossomed into this $1.7 trillion indebtedness, and how to go about treating borrowers fairly has been a contentious issue. So just to kind of put this in perspective, let's go to the next slide. A huge advocate of loan forgiveness, Senator Elizabeth Warren, states that forgiving $50,000 of federal student loans would liberate 36 million out of 45 million borrowers. That's 80% of federal loan borrowers from their loans, and 9.8 million defaulted borrowers. That's 98% of defaulted borrowers would find their debt being forgiven. That speaks to the breadth of the relief requested by Senator Warren and other senators that support this position of forgiving $50,000 of student loans. Next slide, please. President Biden campaigned on the idea of granting a $10,000 loan forgiveness. And that would forgive 15 million federal student loan borrowers of their entire debt. That's a third of federal borrowers. And 4.6 million of those defaulted borrowers, approximately 44%, would have their loans forgiven. Both the forgiveness urged by Elizabeth Warren and the forgiveness campaign promised by President Biden have broad support from various constituencies and equally vocal critics. Let's see, next slide, please. I have a quote here from the president of the NAACP. That is the nation's oldest civil rights organization, and they have called for the cancellation of debt. And they, as an organization, see a disparate impact on people of color, and see the amount of student loans owed by people of color as standing in the way of home ownership and other accruals of wealth, and they see it as not only a financial but a racial issue of having disproportionate impact. Next slide, please. Let's see, I think we are on the American Bar Association, perhaps a less a less sympathetic group, the largest voluntary association of lawyers and legal professionals in the world. They wrote directly to Richard Cordray. He is the Chief Operating Officer of the Office of Federal Student Aid, and they requested relief for student loan borrowers. And in their request is an echo of what the NAACP is claiming. Number one, that there is approximately $150,000 of indebtedness owed by students pursuing professional degrees. But number two, that those loan amounts are typically higher for students of color. And number three, that the amount of these loans typically increase following graduation due to deferrals or inability to pay. And so the ABA has requested very specific relief: suspension or forgiveness of student loans, extension of federal student loan repayment programs to students who borrowed privately. And let's keep in mind that the $50,000 debate, the $10,000 debate is all about federal student loans, and it's not about private loans, which the government cannot forgive. The other request that the ABA made is making the Public Service Loan Forgiveness Program clear and accessible. And they would like the present administration to partner with Congress to allow private student borrowers, private loan borrowers, to convert loans to federal loans. I presume that would have two impacts: one, so that the rates could be lower, and two, so that private borrowers could take advantage of any relief that the federal loan borrowers can access. Let's go to the next one. This is a part of the process here is that Biden has asked the Secretary of Education, Miguel Cardona, to oversee a legal review as to whether or not cancellation of student debt without congressional approval is constitutional. And most experts that have studied this do not expect the president to act without this report. And a report that validated the president's right to cancel student loan debt would be a change in position from the prior administration. The prior administration was of the opinion that the president did not have the unilateral power to cancel debt. Secretary of Education Miguel Cardona is also revising the borrower defense, and this permits students who were defrauded by their educational institution to obtain loan forgiveness. And Cardona is, among other things, shifting the burden from the student to the to prove damages to the institution to prove that they did not defraud the student. And we're seeing the borrower defense get traction in cases of fraud, such as the late great ITT Technology School, which employed high-pressure tactics and other fraudulent practices to get their students signed up into loans. So many of those loans have been forgiven, and it's part of kind of a piecemeal approach that the current administration has taken to forgiveness of loans. Next slide, please. On March 29th, the U.S. Department of Education announced changes to the Total and Permanent Disability Discharge Program. In fact, that program has resulted in a lot of student loan debt owed by disabled persons being discharged. And an interesting side note, the U.S. Government Accountability Office found that 98% of the applicants to that TPD discharge program had their debt reinstated, not because they were too poor to pay, but because they failed to submit the proper documentation. And that really is a disturbing percentage of failed applications for relief. 98% of those applicants just can't submit the proper documentation. It's time to reconsider what the documentation requirements are, and that is underway currently. Finally, there's been a demand from 23 states attorney generals to request various forms of relief from the Secretary of Education, and a continuing moratorium on involuntary collections, allowing suspended payments during the COVID virus to count towards public service and IDR plans. They want delays in forwarding accounts to collection agencies. This goes really to the problem of finding people after a year and a half of moratoria. Stronger protections for defrauded borrowers, and changes to the bankruptcy discharge laws. These changes, and let's go to the next slide, could directly affect loan servicing. We're seeing, by delaying the deferral of defaulted loans, extending recertification for IDR plans, creating cure opportunities, and enhancing the borrower defense rules, and otherwise reforming the IDR plans. And we're seeing that sort of rollout process happen. October 1 is not going to be a light switch. If I'm going to offer a little prognostication here, I think we're going to see some of these reforms come into place before then, and we're going to see a slower rollout of the servicing of student loans and the referral of student loans for collection. There are some other loan forgiveness initiatives which bear mentioning. Senators Mitt Romney and Kyrsten Sinema introduced the Earn to Learn Act in April, which basically proposed a matching college matching savings account for Pell Grant eligible students. So for every dollar that the student deposits in savings for college, the matching savings account would contribute $8 toward that student's education. And on April 9th, President Biden proposed an additional $3 billion in Department of Education funding for federal Pell Grants. That would increase the maximum Pell Grant by $400 per borrower per year, from about $6,500 per year to about $6,900 per year, which can offer some relief. We're also seeing some private initiatives. In one example, the Rhode Island Foundation tried to encourage, in an attempt to encourage educators of color to enter the Providence public school system. They raised a few $1 million to help with these new teachers' student loan debt. And they pointed out, in the foundation points out the disparities between the students of color, representing 80% of the students in the district and just 20% of the educators being of color themselves. And the foundation set up a program to assist teachers of color who enter the Providence school system to have some relief after working in the school system. Similar, there's a teacher loan forgiveness program targeted at STEM teachers, and that is something that is administered by the U.S. Department of Education and offers up to $17,500 of loan forgiveness. Finally, one additional program merits mention, and I think we're a couple slides behind at this point, Colleen. This is the Public Service Loan Forgiveness program. This is a federal program that allows borrowers in public service occupations to have their federal student loans discharged after 10 years of qualifying payments. It's similar to the income-driven repayment plans. This has suffered from a lack of access and a lack of participation. In another study, just 124 members of the military had their student loan balance forgiven under the PSLF, and 1,410 were denied. Well, that doesn't seem so out of whack until you consider that out of 177,000 active duty members who would qualify for the program, only 11% had submitted their initial certification request. That is a dispiritingly low participation rate, one that my colleague David lays at the feet of the Department of Defense rather than the Department of Education. But it's kind of shocking how little people take advantage of the existing programs, and it either says something about their lack of accessibility or the difficulty of administration. So in summary, I think we can see in a few coming months a continuing push from progressives for a large amount of debt forgiveness, a lesser push from the current administration for a smaller loan forgiveness amount, and a intensified look at existing programs for student loan forgiveness. And layered on top of it all is the coming switch in the end of September from moratorium to October 1 collections. And what that brings us to is our next topic, which is the intersection of COVID relief and credit reporting. And I'm going to turn to my colleague, Ann Dunn, for that topic.
Thanks, Bill. As we briefly mentioned before, in response to the coronavirus pandemic, Congress enacted sweeping legislation commonly referred to as the CARES Act, which, among other provisions, temporarily halted the accrual of interest on eligible federal student loans held by the United States Department of Education from March 27, 2020 through September 30th, 2020. As Bill mentioned before, this has since been extended to September 30th, 2021. The CARES Act also automatically awarded a forbearance to all borrowers. This forbearance suspended payment obligations for educational borrowers who held federally backed student loans. Additionally, the provision dealing with federal student loans noted that for purposes of reporting federal student loan information to the credit reporting agencies during the suspended period, the Secretary of Education must ensure that any payment that has been suspended is treated as if it were a regularly scheduled payment made by a borrower. So in sum, for educational borrowers with federal loans, as Bill mentioned before, this relief is only for loans held by the federal government. It promised an automatic and interest-free forbearance, which has since been extended to September of 2021. The CARES Act, in addition to modifying student loans, also modified the Fair Credit Reporting Act and furnishers' resulting duties. Could we go to the next slide, please, Colleen? The CARES Act modified the Fair Credit Reporting Act, or FCRA as it's commonly known, to provide that if a consumer received an accommodation, which here was an automatic forbearance for federal loans from a furnisher as to one or more required payments, and the consumer either makes the payment or is not required to make the payment as they are here, the furnisher shall either report the credit obligation or account as current, if it was current at the time the forbearance was entered into, or in the case of a credit obligation or account that was delinquent prior to the accommodation, the furnisher shall maintain the delinquent status during the accommodation period, which here for federal loans is set to run on September 30th, 2021. If a borrower did bring their obligation current during the forbearance period, then the furnisher was required to report it as current. Here, for all educational borrowers with federal student loans, the automatic forbearance was an accommodation, and as such, the Department of Education, as the furnisher, was required to continue to report all loans which were current on March 27th, 2020 as current through the entire forbearance period, which was more than 18 months. And if they were not current when the forbearance period began, then the Department of Education was required to continue to report them as delinquent. And could we go to the next slide, please, Colleen? Litigation under the CARES Act has obviously been a hot topic in a number of areas. With respect to student lending, litigation quickly commenced against servicers and the credit reporting agencies. In May of 2020, a class of borrowers was first to file in the Northern District of California. They filed suit against the student loan servicer and credit reporting agencies, alleging that the defendants had damaged their credit scores and mishandled the implementation of student loan relief provided under the CARES Act. In July of 2020, just 2 months later, a second class of borrowers filed suit in federal court in New Jersey, alleging, among other things, violation of the FCRA as amended by the CARES Act. We're watching this area closely, and we anticipate that litigation will only continue to increase once the moratorium is lifted this fall, as servicers and borrowers begin to navigate the new world of student lending in a post-COVID environment. Next slide. I'm going to turn this back over to Bill for developments in bankruptcy discharge.
Well, thank you, Annie. This is going to be another hotly contested area. And, you know, we were in a meeting this morning, and we were discussing the kind of rollout provisions that the Consumer Financial Protection Board have put in place for mortgage lenders. And I'm wondering, David, whether you think something similar might be in store for servicers of student loan debt.
Yeah, so the Bureau this morning, the CFPB, well, yesterday, came out with the final rule finally for servicers for basically starting to lift the floodgates to go back to mortgage foreclosure servicing. And as we all know, Richard Cordray, who used to head the CFPB, is now running the shop over there at the operational level for student lending for their regulator. And we can expect that he's not done. He's over there for a reason. Biden put him there for a reason, and I think we're likely to hear something from him with regard to the floodgates being opened for how student lending default servicing is going to work going forward. For example, with respect to modifications, even if we don't see a regulation coming out of there, we're going to see increased enforcement priorities and activities and monitoring and working with servicers, putting pressure on servicers. It's all a given that we're going to be seeing those things. We've been watching closely to see in what ways they're likely to manifest, and as of right now, it seems to be keeping things pretty close to the vest. But the one thing we can count on is something's coming.
Right, and it kind of makes sense for the current administration to be focused first on the mortgage indebtedness, because that is, as Annie said, $10 trillion. Can't get my zeros straight here. $10 trillion of indebtedness, and the moratoria are lifting sooner than the student loan moratoria, and it's going to be an interesting process going forward. We're going to see litigation over what the servicers have done or what they haven't done or what people say they should have done in the past year and a half, and then we're going to see litigation on what they start doing on October 1st. So clear guidance from the applicable regulators would be, I think, a welcome sign and a hallmark of a well kind of regulated return to normal. We were, as a group, kind of pleasantly surprised that a measured rollout came out of the CFPB. There were a number of folks thinking that the pendulum would have swung from Betsy DeVos in the last administration to the new Democratic administration. And I think the new administration has taken a measured approach on mortgage lending, and we expect that they will take a measured approach on student loan lending. For those of you who are attending this webinar and want to get CLE credit, we have a number for you. It is SS6638. That's SS as in Seyfarth Shaw, 6638. You'll be able to submit for CLE with that code on a form which will be provided to you when we circulate a link to this webinar and to the slides. That brings us to our final topic, which is developments in bankruptcy discharge. And I think it's warranted to give a little bit of history on how the bankruptcy discharge developed over time. In 1978, the bankruptcy code was substantially rewritten, and at that time, student loans were dischargeable. And we've come a long way since then to a point where almost nobody believes that student loans will be discharged in bankruptcy, which I think is probably a bit of a fallacy. But it was interesting to watch the progression over the years. You know, I guess early on there was concern that there was abuse of the ability to discharge student loans. Some experts claim that there was flagrant abuse. Some experts claim that it was a very small percentage, but some clever law students figured out that if they graduated from law school and immediately filed for bankruptcy, they could discharge their student loans. And that resulted in Congress amending the dischargeability provisions of the bankruptcy code and saying you can't get a discharge until you've been out for 5 years. And then that was later lengthened to 8 years. And then finally, that was expanded to include private loans. And that expansion to private lending came at a time when private lenders were entering the market and accelerated their entrance to the market. So the current standard is undue hardship. That's the statutory term used for a bankruptcy discharge. So automatically, when a debtor enters bankruptcy, a student loan debt is presumed to be non-dischargeable. And it's incumbent upon the student loan borrower to commence what's called an adversary proceeding. It's a little civil suit which is within the larger bankruptcy case to obtain a hardship discharge. And there has been some movement in the case law interpreting undue hardship, and that's what we're going to discuss for the next 10 minutes or so. I'd like to start with the classic Bruner test, which is the next slide, Colleen. The case name is Bruner. It's a test which has been applied by the majority of circuits, and a debtor that claims undue hardship has to show that if they're forced to repay their loans, they can't maintain a minimal standard of living, and that this state of affairs is likely to persist for a long period of time, and that they have made good efforts to repay the loans. This is kind of the classic interpretation of the undue hardship standard in the bankruptcy code. And this was recently reinterpreted by a bankruptcy judge in a case involving a student loan borrower by the name of Rosenberg. That's on our next slide. And Mr. Rosenberg, who was a Navy veteran, borrowed $116,000 to attend undergrad and law school. And he owed $221,000 when he filed. He had worked as an attorney, decided that it wasn't for him, and pursued other job opportunities. The the bankruptcy court permitted a discharge of $221,000 of law school loans for a non-practicing attorney, and they did it by reinterpreting the Bruner test and calling it oppressive, saying that the infamous and oft-cited term certainty of hopelessness with respect to the debtor's ability to repay a student loan shouldn't be applied, and this case is currently on appeal. But the way it worked was, and we'll go to the next slide here, the court found that Rosenberg had satisfied the first prong of the test, the minimal standard, because he didn't have any money to satisfy his student loan, and all the money he had was to maintain his minimal standard of living. The court found that Rosenberg was not likely to get a job as an attorney. He was likely to continue for the remainder of the repayment period because the loan had been accelerated. There was no repayment period. It was all due. And then with respect to the third prong, the court reviewed Rosenberg's student loan history and found that during the 26 months that the loan was not in deferment or forbearance, that he'd made 10 payments, roughly 40% of the payments he'd been required to make, and that constituted a good faith effort to repay his student loans. The court found that he had met the elements of the Bruner test. The student loan servicer took an appeal, and that appeal is still pending. The next test, the next case I'd like to discuss is Janet Tingling. Like Rosenberg, she's a middle-aged student loan borrower. She had tried to discharge student loan debt accumulated to obtain a BS and MS in biology, an MBA, and a doctorate in business administration. She had $50,000 of income before filing bankruptcy, and her student loan debt, including principal, interest, fees, and costs, was $59,000. And the bankruptcy court applied the Bruner test and found that she is relatively young, 52 years old, in good health, has 2 graduate degrees in healthcare administration, lacks dependents, and by all indications is able to maintain her current level of income. And the court denied her discharge. She appealed, and a 3-judge panel of the Second Circuit Court of Appeals upheld the bankruptcy court's decision and reaffirmed that the Bruner test was the test of the land in the Second Circuit, and that it had been applied correctly. The takeaway on this is that the panel expressed no interest in modifying or overruling the Bruner standard. There is a minority standard, which is referred to as the totality of the circumstances test. And unlike the 3-part Bruner standard, the totality of the circumstances test asks, can the debtor now and in the foreseeable future maintain a reasonable minimal standard of living for the debtor and the debtor's dependents and still afford to make payments on the student loans? And in answering this question, the courts take a look at all of the relevant evidence: debtor's income and expenses, debtor's health, age, education, number of dependents, other personal or family circumstances, the amount of the monthly payment required, the impact of a general discharge under Chapter 7, and the debtor's ability to find a higher paying job, to move, or to cut living expenses. In short, they take kind of a holistic view of the debtor's circumstances and the potential for the debtor to increase or maximize future income. And they also look at the debtor's ability to participate in an income contingent repayment plan. That is the standard in the Eighth Circuit and also the standard in the First Circuit. It is a slightly different standard than the Bruner standard. The U.S. Supreme Court was asked to review and reconcile the two standards. And let's go to the next slide. Like many other things, the U.S. Supreme Court declined to review in this case, the Fifth Circuit's affirmation of the Bruner test, and the details of that were that the borrower, who had entered the college in her 40s, got a bachelor's, a master's, and a PhD, sought to discharge $350,000 of debt. The courts below found that she could not satisfy the second prong of the test, which is that circumstances will exist for the remainder of the repayment period. Now, McCoy, who at the time of her bankruptcy was 60, claimed that her disabilities would have qualified her for a discharge under the totality of the circumstances test, and that at the age of 60, her circumstances were not likely to change. In this battle, consumer rights groups filed amicus briefs. The government responded that the differences between the two tests were limited, and the Supreme Court punted. They declined to review, and they're leaving the circuits to their individual determinations. The next issue that we're going to see, and we're going to see this litigated again and again, are what exactly is the servicer's burden of proof in proving a student loan. So recall that student loans are automatically non-dischargeable, and if a student borrower challenges the dischargeability and brings an undue hardship case, that student loan borrower can also claim that the student loan itself does not fit the definition of student loans under the Bankruptcy Code. And that brings me to this question: what is a student loan? Well, servicers that are going to litigate this issue need to be prepared to show what a qualified educational loan is. And I've put the definition in this slide, but it has numerous requirements. Number one, it has to be taken by a taxpayer. Number two, it has to be taken to incur qualified higher education expenses. Number three, it has to be incurred solely to pay those expenses. and in close proximity to the time of attending an educational institution, and the student has to be an eligible student. Let's go to the next slide. There's a further qualification that the student that receives the loan must attend an eligible educational institution. And without going into too much detail, the Bankruptcy Code refers to the Internal Revenue Code for the definitions of eligible educational institution and eligible student and eligible loan. So it is there are a number of touch points that any servicer who's going to litigate this issue, or any student borrower who's going to litigate this issue, are going to want to touch on and establish to make sure that the student loan itself qualifies for as a non-dischargeable loan. Let's go to the next slide.
Before you move on to the next slide, I just want to point out for our audience that there's also been some AG enforcement activity in this area, and we know because we've had a student lender servicer client in this area with regard to when these student loans, if they're considered potentially as dischargeable student loans because they don't meet the criteria to be a non-dischargeable student loan, and this type of thing can be easy for a servicer to potentially miss or just get wrong. That there is this potential for enforcement activity by attorneys general and regulators to say, hey, you got this wrong, and we're going to hold you accountable for it. And if you want to add any color to that, Bill, be my guest.
I think you're absolutely right. The only thing that I would add, David, is that it's kind of almost a two-step process. I mean, what is the AG's ability to police this subject, and then policing the subject itself are both issues in that sort of enforcement activity. Returning a little bit to our litigation scenario, I just wanted to point out a couple of cases that have parsed the definition of student loans. And there's a case from the Bankruptcy Court in Maine which denied summary judgment to a student loan lender on the grounds that the student loan lender didn't provide sufficient evidence that the debtor was a taxpayer. It's almost self-evident, but it's not self-evident. So if you're going to go to the mat, you better be prepared to show that your student is a taxpayer. That's an element of an eligible loan. I think it goes doubly for the other requirements of the loan. The eligible educational institution requirement is one that requires the school to be accredited, and there are challenges for servicers in this department, especially those servicers who have acquired loans and may not have the history of the loan at its disposal, or closed institutions. Those are both difficult issues for a servicer to enforce. There are other elements here that the servicer may run into trouble with, loans taken for bar exam materials, loans taken to go to flight school, loans taken to pursue other non-qualified educational opportunities. So the case law is a warning to lenders and borrowers that each element will be strictly enforced. I want to throw in one final note about another case here in Massachusetts where a self-represented litigant sought a undue hardship discharge, and under the totality of the payments, totality of circumstances test, the court denied her a discharge, but since she was 51 years old, the court said anything that's left after you enter an income-driven repayment plan and fulfill it, so she'll be 70 when she does that, will be discharged. So we're starting to find borrowers and servicers paying heightened attention to elements of discharge, and we're going to see a lot of litigation in the future over whether existing loans qualify as dischargeable or non-dischargeable. And I've gone 1 minute over our allocated time, and I want to bring this to a prompt close and not keep people over time. So I think we're just going to end on the note that we can expect more litigation in this area, more enforcement activity. We've got an upcoming political issue which needs to be resolved, and maybe we can come back 6 months from now and see where we are. If I can get Annie and David back here with me, that would be a joy. Thanks so much for attending.